Stephen, welcome back. Today I have pulled together a good number of estate planning myths that are likely to cost Florida families thousands, if not more, numbers of dollars. Are you ready? Let's dive right in.
Yeah, it sounds great. Thanks.
Okay, cool. So, why are myths about estate planning so dangerous for Florida families?
It's basically unintended consequences. That could be uh, a great increase in time and energy and cost to go through the probate process. It may be, um, I had one probate that went over 8 years because there was a dispute with a former business partner who felt like he should have some of the estate. It could be choosing the wrong um, or, choosing the wrong fiduciary, the person who's in charge of the estate or the person. And those things can cause absolute chaos. It could be, that they didn't think about the money is now going to the grandchild who's under 18 years old. So now we're in a guardianship situation for that grandchild. So there's it's basically comes down to unintended consequences.
So let's hit probably the biggest myth that's out there because we've talked about in a previous episode about probate, and that word comes up a lot when thinking about end of life and estate planning. And this big myth is that a will avoids probate. So that's one of the biggest misconceptions. Why is that not true in Florida?
Well, the very definition of probate is proving a will. So, if you have a will-based plan and a person passes away and assets are titled in their individual name, it has to go through the probate process, which is the way the courts retitle the asset to the beneficiaries, to the names of the beneficiaries. So that can't happen unless probate happens. Okay. So you can't sell the house that you inherited unless you go through the probate process. You can't interact or you are able to retrieve bank accounts, financial accounts without going through that probate process.
So then if a will doesn't avoid probate, just give us a little basics of like what does the will actually do?
So wills are a great, I mean, don't get me wrong, wills are a great idea. They're still an important piece if you don't do a trust, because what it does set out who is in charge of your estate when you pass away, who has the responsibility of gathering the assets, paying the creditors, and making distributions to the beneficiaries that you've chosen. And so that's another big um, part of a will is you get to choose who gets your assets, when they get the assets, um, how they get the assets. That can all still be in a will as well. So it's still a very important document, but also for younger families who have minor children, that is where we put who you designated if you unfortunately pass away, who's going to be the guardian of your children, which can sometimes lead to big fights as well between families. But if you have it designated in your will, well, that goes a very long way towards reducing those fights.
And in your opinion, I've heard about everybody has a will, they should have a will before they die. Why do you think so many people are surprised to learn that having a will still means you have to go through probate?
Just misinformation. I think what it used to be is the um, barbershop talk or the beauty shop talk. People just, talking about things that they may have heard, and they just continue that sort of those misconceptions, and they just kind of perpetuate from there.
Once the documents are signed, you're done. So why is it a mistake to think that you never have to update estate planning documents?
People like to do it and just put it away, but life changes. Life changes a lot. It can happen quickly. It can be your assets change. So I had a client years ago that came in and said, and I was working on a business deal with him, And he said, "Oh, by the way, I may need to get my estate plan done." I said, "Well, that's great. Let's talk about that." I said, "When did you get this estate plan done?" He said, 26 years ago. I said, "Okay. Where are you living?" "Georgia." And he's now living in Florida. Um, have your assets grown? "Oh, yeah. I have about 100 times more in assets than what I had before." "Okay. Has anything changed in the last 26 years?" "Well, my son passed away." Um, okay, well, those hit almost all the boxes of each and every single time when he should have come in to get his estate plan updated. The only probably other 2 times is I'm sure the loss has changed in those 26 years. But also, if you go from like a vertical to horizontal, meaning you have an unexpected illness, that's a time to get your estate plan reviewed as well. Because you want to make sure that all those things are in place with your current thinking, with your current assets, with your current family makeup, all those things that we are up to date and when that unfortunate time comes, and none of us really know when that is, that you're prepared
Yeah.
and your
So,
family prepared.
real quick, just maybe list like the top 5 or so life changes that should trigger a review.
So it's change in assets. It's adding children or family members, divorce or remarriage. That's a definitely a very big one. Um, big changes in law and your health.
What are some of the scary things that can happen in Florida when someone dies without proper documents?
So there's besides probate, um, there's probate litigation. People fighting over what they think they are entitled to. It could be um, the elective share law, where you may have an estate plan, but the spouse says, "I didn't get enough, and I want my 30%, which is the elective share." Um, it could be the homestead wasn't done correctly, and so therefore the spouse gets a life estate, or maybe they can also elect to take tenants in common with 50% when they thought they were receiving everything. So, um, planning goes a very long way to figure out what those are, but also to make sure that you're doing it in a way that complies with Florida law. If you remember what the question was again.
No, no, that's the was some of the scary things. That was helpful. Um, so you've already mentioned different family situations, things like second marriages, blended families. Um, do you have some examples you could give us of where not having any documents and then things like second marriages or blended families were involved where it got particularly messy?
Yeah, and so anytime that and one where is very sad. The surviving spouse, the husband owned a couple car dealerships, and unfortunately, I think it was back in 08, 09 when the whole economy was cratering. And what happened was the dealerships would kind of move the flags around. The flags are very important, being or is it a Cadillac versus a Chrysler or whatever it was. And unfortunately, um, decedent before he passed away, right before he passed away, didn't got one of the good flags taken away. He was stuck with the bad flag. And the spouse was very used to a certain lifestyle because good car dealerships make a lot of money. And he didn't keep up with the estate plan. She was a second, maybe third spouse, I can't remember what. And so therefore the homestead was only in his name. And so she had to split the homestead with the children. And the children could not stand her. And was trying to help her all these through these things. And so there was an asset that was declining greatly that we had to go through the probate process and try to catch that kind of falling knife. The children were making her life an absolute hell, telling her to get out of their house because now they own 50%. She ended up committing suicide,
Mm.
and she was 60, I think. Still had a big life ahead of her. Number one, it was the life that she originally thought because of bad planning. Um, and also because the children made it so horrible on her regarding this house because he didn't do the proper planning for that either.